Thanks for joining us at Lighthouse Lab Services for today's webinar, How Labs Can Comply with New Surprise Billing Rules, particularly uh, overseen by the No Surprises Act, the new federal surprise billing regulation that went into effect on January 1st. I'm going to quickly introduce our speakers today. My name is Alex Mitchell. I'm a communications manager with the Lighthouse marketing team. Our guest speaker today is Danielle Tangorre, a partner with Robinson and Cole, a national law firm with a focus on healthcare law. Ms. Tangorre represents and advises on a broad range of healthcare providers, including clinical laboratories, long-term care facilities, behavioral health providers, substance abuse providers, physician group practices, and licensed healthcare providers. She is a member of the Health Law Group, which consists of a team of experienced healthcare lawyers trained to advise clients on meeting business objectives within the confines of a complicated legal and regulatory environment. Ms. Tangorre's specialties include advising clients on operational and compliance issues, federal and state fraud and abuse laws, including Stark Law, Anti-Kickback Statute, and ECRA, HIPAA, and other regulatory matters. And we want to really say thank you for her time today. We greatly appreciate it. Danielle will be joined by Ann Lambrix from our team with the Vichette RCM division of Lighthouse. Ann serves as Lighthouse's Vice President of RCM Consulting, heading up the division's day-to-day operations. With more than 20 years in the medical insurance and billing industry, her experience provides for an insightful analysis of revenue cycle and payer trends impacting reimbursement. And Ms. Lambrix also holds an MSJ in health and hospital law. So thank you to Ann for her time today as well. And now for those of you who may be joining us for the first time today, I'll just do a little bit about Lighthouse. With almost 20 years of experience, Lighthouse Lab Services has become the nation's leading and most trusted end-to-end full-service medical laboratory consulting and recruiting firm. Whether you're looking to start a lab or looking to grow your current business, we offer labs a way to accelerate their success. And again, if you're interested in learning more, please reach out to us after the conclusion of this webinar. And with that, I'll turn it over to Danielle.
Thanks so much, Alex. Good afternoon, everyone. It's a pleasure to be here talking to you about this with Anne as well. Just a quick disclaimer, this isn't attorney-client advice. It's giving general information. I'm not creating a specific attorney-client relationship. And as you are probably aware, the No Surprises Act is still in development with regulations being promulgated by the government as we speak, and litigation as well. So all of this is subject to change, but we will address that as we go along. So just as a little bit of a background, the federal law was passed in December of 2020. Regulations began being promulgated mid-year last year. It became effective as of January 1st, 2022. So this is the first year that we're in it. The intent of the law, and I think it's important to keep this in mind, is to protect consumers from surprise medical bills that can arise. There was a lot of publicity, particularly with air ambulance, but also high laboratory bills from out-of-network laboratories surprising patients, and that's what really spurred this law. So you have to remember that patients may not be aware that they're going to an out-of-network facility, particularly for the ancillary services such as laboratory work, and that they receive bills that may be unexpected. And this federal regime is to address all of those issues. And they're currently in the process, CMS is currently in the process of implementing various rules as we go along. There's also state surprise billing laws that you should be aware of. This chart taken from the Commonwealth Fund, I think particularly highlights it well. There are balance billing protections, surprise billing laws in several states, with the dark green being the most comprehensive. And then there are, other ones that are less comprehensive. And then some states are still working on passing or considering their own version of surprise billing laws at the state level. And we will discuss as we go forward in the presentation the interplay between the federal and the state laws. So one of the biggest questions in figuring out the No Surprises Act is exactly when does it apply? And it applies in emergency services, some post-emergency stabilization services, but most importantly, what we're going to focus on for the majority of today are non-emergency services provided at certain in-network facilities. So you have to, we'll get to this, but it's important to know what an in-network facility is defined as. Under the law, it's defined as a hospital outpatient department, a critical access hospital, or an ambulatory surgical center. The regs aren't final, so it is possible that there will be an additional list or additional facilities that are added. In the commentary, one of the debates was whether urgent care centers should be included in this list. We'll have to wait and see whether they're ultimately included. And then it also is important to understand whether you're a participating or non-participating provider, and those that you are working with are whether they are participating or non-participating. So for a lab, what you need to identify is whether, first and foremost, the test is a covered service. If it's a covered service, that means that it is covered and billable to a commercial payer. So the No Surprises Act applies to items and services provided to individuals enrolled in private and commercial healthcare plans, including employment-based group health plans, individual group health coverage, federal employee health benefit health plans, those plans that are sponsored by state and local government employers, and some other ancillary ones. But what it doesn't apply to is any beneficiary enrollees in Medicare, Medicaid, or Veteran Affairs or TRICARE. So if it is a covered service, that's your first question. And then you have to understand whether the specimen collected was part of a visit. And a visit is defined as one that is part of a participating health facility and includes ancillary services such as laboratory work, whether or not you, the lab, are furnishing such items or services at the physical location of the facility. So you have to determine whether the specimen was collected in an emergency, at a hospital outpatient department, at a critical access hospital, at an ambulatory surgical center. Or if you're a hospital outreach lab, you have to understand that the No Surprises Act does apply. And then you need to figure out, if you are an independent laboratory, whether the visit at the hospital, for example, is in network. So we'll take these in part. So the first issue is whether it's a covered service. So is the test covered under the in-network benefits and terms of the individual's health plan? If you have a more esoteric test or something that is not generally covered by insurance, then this is not going to apply. If it is covered, though, by the individual's insurance, then the No Surprises Act rules of balance billing apply. So then the important part is whether your specimen comes from one of those four: the hospital outpatient department, or if you are a hospital or hospital outreach laboratory, then you have to consider all of the requirements of the No Surprises Act. If you're an independent lab and you are doing reference work, for example, for a hospital, then the No Surprises Act applies. And so it would be falling into this category of non-emergency services that are part of a visit. As an out-of-network laboratory, you cannot balance bill for non-emergency lab tests that are part of a visit at an in-network hospital, for example. Interestingly, as part of the rules, the CMS and the government decided that ancillary service providers such as laboratories are not able to use the notice and consent exemption for balance billing. So, what this means is that you cannot give notice to the patient prior to the test being run and get consent to bill them for the out of network charge. So simply, if you're an out of network lab providing services at a hospital, hospital outreach department, or ambulatory surgical center, you cannot balance bill a patient or seek consent to bill for out of network costs. You are limited solely to the in network cost sharing amount and the in network payment rate. So, what is that rate? That rate will depend on certain circumstances, including any state laws that establish reimbursement amounts. So think of those states we saw a couple slides ago and their surprise billing, or whether there is an all payer rate setting model. And then if neither of those scenarios apply, the out of network rate is either the rate agreed to by both the plan and the laboratory, or if you cannot agree to such rate, you would have to go through the independent dispute resolution process, which we'll talk about briefly. The other requirement is that a provider, so whether you're a healthcare provider or if you're at a healthcare facility, such, again, the hospital outpatient department, ambulatory surgical center, emergency department, or if you're providing services and contracting with those in healthcare facilities, then you have to post publicly and work collaboratively to distribute a one-page notice on the No Surprises Act protections and balance billing laws, both federal and state. I think we covered this, but I just wanted to give you an example of what we've talked about. For example, if an individual with an employer-sponsored health plan is referred to a local in-network hospital outpatient department for a biopsy, and the pathologist performing the review is out of network, even though the hospital is in network, then the No Surprises Act applies. The pathologist cannot bill the patient more than the in-network cost-sharing amount, and that rate will be set as we just discussed about. Nor can the pathologist obtain consent to waive the balance billing protections. And then going back to the public notice, if you are providing services as part of a visit at an inpatient facility, such as a hospital, or if you are a hospital outreach laboratory or a lab at an ambulatory surgical center, then you have to publicly post on your website and provide notice to patients regarding all of this, the state balance billing. And there are model consents and notices posted on CMS's website that you should take a look at. In addition, you have to have contact information for state and or federal agencies that an individual can contact to report where a patient can report a provider or healthcare facility for violation of the balance billing protections, and to go through the independent dispute resolution process if it's in if the patient is able to use that as well. You, as a provider, are not required to make the disclosures if you don't furnish items, and if you're an independent lab and you don't work with a hospital or receive samples from a hospital outreach laboratory or ambulatory surgical center. So just briefly, in the event that you have to avail yourself of the independent dispute resolution process, the process requires that after 30 days of negotiation between you and the insurance company determine whether you can agree to a rate, then you can initiate an independent dispute resolution process where the parties will select a certified entity, and if you cannot agree to a neutral one, one will be appointed. Both sides will submit payment offers and supporting documentation as to the appropriate rate, and ultimately the dispute resolution entity will deliver binding ruling on what the rate should be. The IDR process has solicited and put forth a certification process for dispute arbiters to be qualified to do this process. Um, and we're going to skip for now the good faith estimates, but there are provisions in the law about good faith estimates depending um, if you're a hospital outreach laboratory that you should work with your facility to deal with. So for the timeline, once you start the IDR process, there are a variety of deadlines that you have to be aware of. We're not going to go through all of these, but ultimately um, there is a process that you have to go through. There are also factors that the arbitrator will look to, and right now there's a conflict or perceived conflict between the how this independent dispute resolution process will take place. Um, Both the AHA and AMA filed a lawsuit over this process on December 9th in DC. They have argued that the regulations exceed the department's statutory authority because the department created in their opinion, a different focus for the factors that are weighed under the IDR process. It's their position that this process put forth in the interim final rule issues the rule to be one-sided in favor of the insurers. The insurers have filed amicus briefs supporting how the department interpreted the law, and the parties are currently still in process of having that lawsuit decided. We'll have to wait for that for a while as that winds its way through the court, and we'll have to see if that changes the overall process for the independent dispute resolution process.
Well,
Um,
thank you very much for that portion, Danielle. Before we turn it over to Anne here with some comments from Danielle for next steps and looking ahead, I just wanted to offer to everyone, if you'd like to follow up with Danielle from today's presentation, you may do so by clicking that button and filling out that form. If you don't want to fill out the form right now, we'll also have her email address available at the end. So please, if you have questions, follow up with her at her team. They'll definitely be able to get you squared away. Anne?
Thanks, Alex. Thanks, Danielle. I know this for me has been a very interesting and almost complicated process. The No Surprises Act has been around, and as Danielle pointed out, we've seen this surprise bill laws being passed throughout the country, various states. So we're all pretty familiar with surprise bill and what that means. But again, the complexity of the law and understanding how this impacts you
I
and your
think we can hear
business.
you, Anne.
Um, I'm sorry, can you not hear me?
No, you're fine, Anne. I'm
Okay,
sorry. I think a
that's fine.
microphone just got unmuted.
Okay, perfect. Thanks, Alex. Sorry about that. So again, I just wanted to point out some things that we're recommending as far as next steps and looking ahead as labs and pathology groups and again, people that we're working with are trying to navigate the No Surprises Act. Um, my guidance has been if you're a hospital based pathology group or a laboratory, you may have already been reached out to by your facility, by administration or for the insurance department. They may be coming to you looking for a list of payers that you're participating with. So you're going to want to review those contracts and understand who you're participating with. I mean, you should have a pretty good gauge on who you're in network with and out of network with. But it's a good exercise to look at that and again explore if you're out of network what your processes are. So um, making sure that contracts, if you have a third party biller, if you're using a billing software, that the contracts are loaded appropriately in the system, that your system is taking those in network allowances as paid in full, or if there's a patient out of pocket, due to their in-network plan that's billing appropriately, but you're not balance billing these patients if you're out of network. So it's again ensuring that your contracts are loaded as well as your billing vendor is current with with your patient billing policy, and that they're able to identify again the difference between a balance bill, between your bill charge and an allowed amount versus a patient out of pocket expense, a deductible, copay, coinsurance, etc. And that they're not balance billing. We really want to make sure you're not balance billing with this new law in place. And finally, I think it's really important to tie that all together, to make sure that you have some sort of billing compliance plan in place. Again, if you're hospital based, many of my groups, utilize the hospital's compliance plan. But what we're doing is carving that out, particularly when it comes to patient billing, and making sure that the group and or the laboratory is in line with patient billing laws, and that they have those policies outlined. It's very clear and specific, what what the biller should be doing in regards to patient balances. And so having those in place and walking through that, again, ensures that you're compliant and that everybody is in line with what should be happening. So we highly recommend to do that, reviewing your billing compliance plan. Danielle, is there anything else that you would recommend?
Yes, thanks, Anne. I think those are all amazing points. Part of both the review of your billing compliance plan and as to your first point about uploading your contracts, you also need to review the state laws. So for the states that you are soliciting or receiving samples from, most of the state Surprise Act laws are based on where the patient lives, but some may be based somewhere else. Um, you need to do a full review of those state laws where you are either in or receiving samples from. Make sure that those rules are also uploaded into the system and incorporated into your billing compliance plan. Some of the state laws do have requirements that extend past hospitals and urgent care centers, or emergency settings, and apply to even primary care settings and things, or physician offices. And that is completely dependent upon the state. So it kind of creates a very complex maze of laws for laboratories to understand. And that's why this reviewing your billing compliance plan and making sure that all your parameters are set within your billing system is incredibly important.
Well, thank you for that, Ann and Danielle. That was extremely informative, and I see we have a few questions that we're going to try to tackle here. Right ahead of that, I want to also give the offer for anyone to follow up with our RCM team. If you're interested in learning more about Lighthouse and Bichette's RCM services, feel free to fill out that form or follow up at the email address listed below. Turning to the questions here, we'll start with one from Jay Flanagan. Do the non-surprise laws in states noted in the table shown earlier in the presentation apply to clinics and physician facilities beyond hospitals, etc.? And I would think that would probably depend on the state you're in. Am I correct with that?
Alex, you are correct. It will depend upon the state or the state that the patient is in. So you'll have to review each state law to see whether it applies or not. But it's quite possible, as I just mentioned, that it may apply to other settings, both clinics, physician facilities, primary care practices, and the like.
Thank you, Danielle. And I saw someone also just asked a question, and I think this is a particularly hot one. Do you know of any resource where these state laws are tidily bundled up to review, or is this kind of playing a game of whack-a-mole and having to track them all down?
There seems to be a few resources that have been published on the web. I haven't reviewed all of them. I think the Commonwealth Fund that I took that um, the map earlier has a good starting point. But I would say that you should consult your attorney or your in-house counsel, your compliance officer, to make sure that each law is reviewed independently. Um, because there are nuances that I don't think everything publicly posted goes into.
I'm going to second that. I think it's very important to make sure that you have legal counsel, an expert review of these laws to make sure that you're compliant. If you have, just a regular schmo like me, reading it, I can have some good takeaways based on my expertise and knowledge of the industry. But when you get into some real detail of the policies and guidance, it's good to have a Danielle on your side to make sure that you're really fine tuning that letter of the law on your practice.
Thank you both, Ann and Danielle. Moving on to a question from Denise. We are an independent lab and do not see patients. We receive surgical specimens from hospitals/clinics. How would the non-surprise laws/balance billing apply directly to us? I believe we might have touched on this a little bit earlier, but is there anything additional we can say?
Sure. So I meant for that particular, as an independent lab, you would need to determine for the surgical specimens you're receiving, if those hospitals are in-network facilities. If you are an out-of-network lab um, providing services to the hospital, then the No Surprises Act absolutely applies to you. So you would need to have an understanding as to the specimens you're receiving, whether you're in-network with those payers or not. If you're not, then you need to work with the hospital regarding, determining those samples are coming to you, and you'll have to comply with the No Surprises Act as we walk through, including not balance billing those patients where you are out of network and the hospital is in network.
Thanks, Danielle. Jumping back to the state laws versus federal. I have a question from Serena Marshall here. Are the state laws based on practice location or the state the patient resides in?
It depends. Most, well, I'm not going to even say most. So it can be both as to where the practice location or the patient lives. And it is really one of those nuanced things where you have to read each state law to determine uh, how that applies.
And I just stick with the theme here since we have more questions on state versus federal. Do the state laws generally supersede the federal laws?
No, this is one of those also complex areas. State where the No Surprises Act is silent. So, take for example, primary care physicians. The state law will control, but that's not necessarily true where we're talking about hospitals. They're, the federal government and the states are sometimes starting to publish how those laws intersect from each of their state. Um, and so if you are an independent laboratory out of network getting specimens from a hospital, the No Surprises Act likely will control unless the state has even greater protections than what is set forth in the law. But if the state law, for example, allows balance billing in that circumstance, that will not preempt the federal law.
Okay. And I believe we have question or time for one more question here. So maybe we could expand a bit upon the good faith estimates with a question here since we didn't touch on those very much. Um, Jay asks, are we correct to understand that labs must provide good faith estimates to anyone who requests one, regardless of the facility type and regardless of the insurance coverage?
Good faith estimates have to be provided, and it depends whether we're talking about uninsured self-pay or in the circumstances of the No Surprises Act applies. So it's a little bit complicated, and I think that one should probably go offline.
Excellent. Okay, I think we have a few questions still hanging out there, but
Alex, can we answer? I
oh
think
yeah,
I can answer Ruth's question. I think it was Ruth, but as far as billing for patients, copays, deductibles, um, my understanding, Danielle, and correct me if I'm wrong, if the insurance company processes at this point in 2021, um, if the insurance company processes a balance to an out-of-network deductible, we can bill that to the patient. And I believe they're working on again for 2023, where the insurance company will need to provide the again out-of-pocket expense as if the patient went to an in-network facility, but that's not firmed up yet. So they're not going to start enforcing that till 2023. Is that correct?
And I believe that's correct. We're still in the process, and that's one of the ones subject to potential change as we see the
Hmm.
regulations come out this year.